Good morning and welcome to the DC Court of Appeals. As a general reminder, we ask that you mute your cell phones at this time so as not to disturb this morning's arguments. Thank you. We'll be starting shortly. All rise. All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia, Court of Appeals, will come here and give your attention. God save the United States and its own court. This own court is now in session. Please be seated and come to order.
Hi, everybody. Welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's regular calendar. First one, looks like everybody's all set, is number 23 CV 128, District of Columbia versus Stephanie Taylor. Whenever you're ready.
Good morning, and may it please the court. Brian Leach for the District of Columbia. With the court's permission, I'd like to reserve 3 minutes for rebuttal. This was a damages-only trial in which the district admitted liability for the accident. Yet the trial court allowed plaintiffs to present irrelevant evidence of liability and prevented the district from offering probative evidence of damages on medical bills and lost wages. The court then compounded those errors by adopting a confusing verdict form that invited duplicative recovery by allowing separate awards for several overlapping categories of damages. For any or all of those reasons, this court should reverse and remand for a new trial. I want to be clear at the outset what we mean when we say liability evidence. The focus of our challenge on the first issue is testimony about training and facts and details about Officer Copeland's negligence before the accident. Those facts go to why the accident occurred, which even plaintiffs admitted below was not at issue and not necessary for the jury to decide. We stipulated to material facts related to how the accident occurred, which is to say the van rolling downhill, going over the curb, striking Ms. Taylor, and we stipulated to our liability based on the negligence of a district employee who failed to properly secure the van upon exit.
You describe this evidence as inflammatory. And can you tell me what you mean by that and point us to, places in, you don't have to do page and line, but in general, where do you see this as inflammatory?
It was inflammatory in a few respects. Part of this has to do with the way it was used in opening and closing. The evidence related to Officer Copeland's negligence, for example, at 197 to 198, plaintiff's counsel walks him through the facts related to that. When the vehicle was found, the key was still in the ignition. The parking brake had not been engaged. It had not been put into park. It was still in drive. Those facts, in light of this overall narrative of the district, the story of malfeasance, as my friends on the other side put it in their brief, all of this was part of an overarching narrative that the district is a negligent wrongdoer that should be punished for for the misdeeds of its employee.
In some ways, it kind of reminds me of what in the criminal law context is referred to as Johnson evidence. Is sort of like evidence that gives you the context of, that it's almost like you would want to know what it was. You have to kind of understand it to even understand what you're dealing with. Now, I understand that's a completely different context and there are reasons to keep it separate here, but why isn't this just a little evidence to give the jury some flavor of what happened?
I think once Officer Copeland's negligence is admitted and we've admitted to liability, the facts of his negligence before the accident, the probative value of that plummets, if not disappears altogether. And so I acknowledge that they are background facts, but the difference between these types of background facts, and I'm not familiar with the Johnson principles in criminal law, but these background facts went far beyond anything that related to or necessary to prove her damages.
We have a carve out though, which recognizes the relevance of the surrounding facts to force and impact, which is directly related to damages. So why didn't the explanation of how it came that this car rolled down the hill and crashed into Mrs. Taylor, why wasn't that permissible background related to force and impact?
Well, the van rolling downhill and being unoccupied and going over the curb and hitting Ms. Taylor, we were willing to stipulate to those facts. And I can give you record sites for this. This is JA 41, 63, and 97 in the pretrial conference. So we don't dispute, Your Honor, that those facts would be relevant. The reason we objected to them was because we were willing to stipulate to all of those material facts.
Let's talk about the difference between a stipulation and a judicial admission. Your opponent says it takes two to stipulate, and we weren't willing to agree to their lifeless description of what happened. But why didn't you tell the judge, this is a judicial admission, it takes liability off the table, forget about a stipulation?
Well, we did. I would acknowledge that there's a somewhat of a semantic difference ultimately between a judicial admission and a stipulation. A stipulation obviously is an agreement. Judicial admission is one-sided. We made clear that we were admitting 100% fault. I mean, at JA 94 to 102, you can read the pretrial conference transcript. We made this fact clear repeatedly. The trial judge essentially said, I recognize you're willing to stipulate to these facts, but you haven't reached agreement with the plaintiffs, but the plaintiffs never identified exactly what was material that we had omitted. They had different verb choices. They wanted to use terms like careen. They had different adjectives. They wanted to say uncontrolled, but they never specified exactly what the material facts were that were omitted from our stipulation and theirs. And they
So
didn't, I'm sorry.
normally in this area, admission and exclusion of evidence, we're talking about abuse of discretion, which is a pretty forgiving standard of review. You claim that there's binding precedent in your favor, and I haven't found it yet.
Oh, I'm happy to tell you what it is. Curry versus Giant Foods.
It doesn't get you there.
I,
Curry says in the passage I think you're focusing on, it was not incumbent upon the judge to admit evidence ultimately to establish a matter conceded. It's not incumbent upon is not a rule of law. It says we're not going to overrule him for not having done so.
and I appreciate that passage in Curry. There are other aspects of Curry that I think go further. There's a statement earlier in the decision where it says, this court says, it's difficult to conceive how this negligent training or supervision evidence would have had any relevance whatsoever in a case where the principal's liability for the acts of its agents is not disputed. And that's exactly this case. When it comes to the testimony on training,
Well, counsel, let me take you into left field a little bit. If we weren't talking about liability and we're just talking about damages, which is really what the trial is about. Hypothetically, in a scenario where someone was seeking punitive damages, which I'm not sure they have to always explicitly say up front, because it's always within the inherent authority of a general jurisdiction court. Could some of these facts not be relevant to that?
they could if the defendant was not the district. Punitive damages, as I understand it, are not available against the district. And I think part of what Your Honor's intuition is getting at is that what they were arguing was damages for punishment rather than damages for compensation. And so if there had been a different defendant, those types of arguments might have been available because they might have been able to plead punitive damages. But all we have here are compensatory damages. So this case really is, when it comes to the testimony about training, is on all fours with Curry versus Giant Foods. And I acknowledge, Judge Fisher, that this is a different posture because that case was affirming. But I don't think it was simply a 50-50 affirm on abuse of discretion case. I think the court went further and noted it couldn't see how the evidence of negligent training would be relevant at all when liability is undisputed. And that's essentially what we have here. And plaintiffs have never attempted to distinguish or address Curry at any point in this litigation. I mean, that has to mean something.
I think I can agree with your argument to my colleague, Judge Howard, that a lot of the plaintiff's arguments sought to punish the district rather than to compensate Ms. Taylor. But I didn't find anywhere in the record where the district objected to the arguments made in opening statement or closing argument.
Your Honor, I think it was included fairly within the scope of our motion in limine and the arguments we made regarding the evidence, the liability evidence, because those arguments all depended on the evidence that we had objected to as being inadmissible. I would acknowledge there was no direct objection during opening and closing to those statements, but we registered a standing objection that the plaintiffs accepted at 129 to 130. They said, we're fine with a standing objection. We won't argue waiver or anything like that.
One could have argued the evidence about fault without going in to punish them because they've waited so long to give her just due. So I'm not sure I see their opening and closing arguments as included within your motion in limine.
I understand Your Honor's point. I think another role played by the opening and closing arguments goes to the prejudicial impact of this liability evidence. So even if you disagree and say we don't have a freestanding objection or claim premised on their arguments, the fact that they were able to use this liability evidence to further this narrative in opening and closing is, I think, a strong indicator of how prejudicial some of this inadmissible evidence was.
How do we go about determining in a damages trial, what may or may not have affected the verdict? In a way, the verdict itself is kind of arbitrary. It's, $1 million exactly, really, that's where it's settled. It's how can you look at the things you're complaining about and kind of connect it to the verdict.
I think in this case, it's actually an easier task for the court because of the verdict form that we have here with these confusing, redundant and overlapping categories of damages. So when you have evidence that is, triggering a punitive instinct in the jury, and then you have them presented with a verdict form that includes categories like the extent and duration of physical injury, and then past physical pain and future physical pain, and then the effects of a physical injury on physical well-being juxtaposed with emotional well-being and emotional distress. I think this is an easier case to make that determination. I would acknowledge it can be tricky in other cases where there's a clearer verdict form. But here, when you've got these kinds of categories, and it's the last thing the jury sees before it renders its verdict, I think it's extraordinarily difficult for this court to look at all of these errors collectively, particularly, and come away with a sense of fair assurance that these errors did not appreciably affect the verdict.
Help me with the verdict form in light of the instructions that were given. It is correct that the verdict form pretty much maps onto the categories that the judge outlined in the standard instruction. And you didn't object to that instruction. So let's assume the following. That instruction was given without objection, and the verdict form had one line. How much do you award Mrs. Taylor? And they wrote in $1 million. Would you have a preserved objection that the categories were overlapping and impermissible and thus the verdict cannot stand?
No, we don't have an objection to the jury instructions, but this is a critical point, Your Honor. I think you're onto something important here because jury instructions and verdict forms serve fundamentally different purposes. The jury instruction is providing them elements and considerations for the assessment of damages. It instructs them essentially how to decide the issues. The verdict form tells them what issues to decide. And when it's telling them here is a separate line next to each of these categories, by the way, with no overall total to begin with, this can't be a case where they argue the jury was just allocating an overall sum. I think we have to assume the jurors were following the verdict form, and the verdict form was specifying a different amount for each of these as though they were separately compensable elements of damages when they're not. They're subcategories of the same category of damages, pain and suffering, because you have the extent and duration of a physical injury with the effect of a physical injury. I mean, the effect of a physical injury is necessarily going to include pain. It's necessarily going to include emotional distress.
I think you have agreed with plaintiffs that an abuse of discretion standard governs a trial court's decision about what verdict form to use. Why is this an abuse of discretion in light of the jury instruction that you don't fault?
Right, because jury instructions can't necessarily be transferred over to the verdict form is the first point I would make. The second point is that the verdict form here fails to honor this court's admonition that verdict forms should be drafted in a way to avoid even the slightest possibility of a misapprehension. This isn't a case where you can just say, well, this was close enough. This got at all the general ideas the jury needed to have. This went far beyond anything the jury needed to have. What it was doing was providing them, I think, a confusing overlapping set of categories that plaintiffs have never attempted in their brief to explain how these different categories have different meaning. And so even on abuse of discretion review, this is clearly, I think, an abuse of discretion, and we preserved this objection. We explained why these were redundant, and the trial court essentially just without any reasoning or explanation overruled our objection. I think that's an important point. The court didn't provide some sort of like detailed reasoning as to why it found this verdict form acceptable. It just said, your objection's noted, it's overruled, this is what we're going to use, without addressing really the substance of our arguments. And, I see that my time's expired, but I do want to get to any questions the court has about the exclusion of our medical bills and lost wages evidence, which was actually plaintiff's evidence that we had attempted to offer. The exclusion of that evidence deprived the jurors of the only objective monetary framework they would have had in a damages only trial, where the only issue essentially was the amount of money that's going to be awarded for pain and suffering damages. Now, we would acknowledge on the morning of trial, they dropped their claim, but it still had relevance to her pain and suffering. And countless courts have agreed with that. And the decisions they have cited on the other side are inconsistent with the logic of this court's decision in Lawson.
Well, counsel, you had pretty extensive cross-examination. You got to deal with a lot of the details of it. The monetary amounts just didn't come in, and those aren't apples to apples with the damages. Why was that so hurtful when the details were there for the jury?
I think there's a few points in that, Judge Howard. The first is that simply because two pieces of evidence go to the same issue or similar issue, I don't think that means that only one of them comes in. The second point I would make is that the details about treatment frequency or the types of treatment she may have received don't provide the jurors the same kind of objective, verifiable dollar figures to rely upon in assessing what the scope of her pain and suffering damages were. And I would acknowledge some of the cross-examination we got in did have an effect in putting forth our theory, but it didn't provide the jurors the same it didn't have the same uniquely probative impact that I think the dollar figures would have had in allowing the jurors to essentially accept that information, consider it for whatever it's worth, and then give it weight or not give it weight. I mean, my friends on the other side have made very good arguments as to why that evidence wouldn't have weight with the jury, or it shouldn't have weight with the jury. But none of those go to the admissibility of the evidence. And they stipulated or were willing to stipulate at the outset of the case that the amounts of their medical bills were reasonable and customary. That's a JA 62. So it's a little difficult, I think, for them to turn around and say, well, our medical bills are simply arbitrary, subjective figures created by the whims of hospital administrators.
One of the challenges, of course, is why do the amount of medical bills have set any objective benchmark to which you can compare the pain and suffering? Some patients are tougher than others. Some would go whining to the doctor every 2 weeks and run up the bills. Others would suck it up and charge forward. So why is this such an objective benchmark that you were prejudiced by its unavailability?
I think those are excellent arguments that go to the weight of the evidence, Your Honor. They still provide the jurors some verifiable, concrete details that weren't available through any other testimony. The rest of the testimony was claims of pain and suffering, observations of pain and suffering, but the dollar figures and, I appreciate there can be differences in the dollar figures, but all of that goes to the weight of the evidence. And part of the reason why it was important was the same reason this court in Lawson looked to economic damages, medical bills and lost wages in assessing the reasonable range of permissible non-economic damages. And Lawson isn't the only case. They have never distinguished or addressed Lawson, but Doe versus Georgetown is another case where the court said, look, a $10,000 verdict for someone who suffered a vicious assault was fair because that person didn't put in medical bills to show the magnitude of her injuries. So this is something the court has recognized, and to adopt plaintiff's position, I think would undercut the logic of prior decisions of this court and would essentially render those decisions, part of them, nonsensical. And I see that my time has expired. Whatever time I have for rebuttal.
Thank you. We will give you a couple minutes for rebuttal.
Good morning, Your Honors. May it please the court, Patrick Regan, along with Christopher Regan, representing Stephanie and Kwan Taylor, who are seated behind me to my left. Let me address the arguments in the reverse order and from the most recent just argued by counsel to the one argued earlier. On the medical bills, that is not the holding of Lawson. That isn't even dicta. All Lawson is doing is quoting the trial judge in that passage that is cited by the district. There is no rational relationship between the amount of medical bills and the pain and suffering suffered by anyone. Ms. Taylor is, as Judge Fisher said, the type of person to suck it up. She could have a ruling that gives credence to the district's argument will simply encourage people to run up medical bills, because now there is some perceived judicial imprimatur between the amount of medical bills and someone's pain and suffering. It's illogical. It's a horrible public policy. It's
So
a
we're just
terrible-
talking about an evidentiary ruling, like it's a question of relevance, isn't it?
Correct.
And isn't relevance a fairly low bar? Are these medical bills really irrelevant?
Wherever that bar is, these don't make it. You can put this bar on the ground and the amount of medical bills don't make that relevance. There is no possible relevance. I could cite to this court numerous cases over my 45 years where medical bills were de minimis and the injuries were catastrophic. An amputated leg, for instance. The medical bills are very low. The damages are catastrophic.
Clarify for me your argument. You seem to be saying now that a judge could never admit medical bills. Flat out, never admit them. And I thought in your brief, the argument was more that there's discretion here. And this judge in this case did not abuse his discretion.
Well, I'm not comfortable with never ever questions. All right, because I think that those, there's always some exception to it. But I would say that Judge Rigsby did not abuse his discretion on this issue. Okay, the district was given complete latitude to cross-examine on the dates of treatment, what was done, the number of times you haven't seen a doctor in 6 months, all of those. There were no restraints put on their cross-examination. And he said that repeatedly. Judge Rigsby said that repeatedly. The only thing he said was, you haven't, and the district never established for the judge, wherever we put that bar, they never established relevancy for Judge Rigsby. There's no way that he abused his discretion on that issue.
Do you think he abuses his discretion if relevancy on its own is merely established?
Well, in a hypothetical situation, if they were relevant on some level, maybe, but the amount of medical bills, I said a few minutes ago that I'm not real comfortable with never ever questions. It's hard for me to imagine in a situation where pain and suffering are the only damages, where the medical bills, the amount of medical bills would be relevant. Okay, but obviously I suspect that with all these bright legal minds in this courtroom, we might be able to come up with one such scenario, but it would be the unicorn. Okay, there's really no situation where they're relevant to pain and suffering.
Counsel, really what I'm wondering about is relevancy on its own enough when we're looking at this for an abuse of discretion? Even if something happened to be relevant,
Right.
if, there are levels of relevance.
Mhm.
At what point does relevancy rise up enough for a very permissive standard of review to justify a reversal and remanded a review?
I think that it is incumbent upon the proponent of that evidence to establish relevancy. It's not incumbent on me to establish relevancy there. And they didn't meet that bar. They offered nothing to the judge and they still haven't offered anything. What's the ratio that they want this court to find? Is it 1 to 100, 1 to 20, 1 to 200? It's an illogical analysis. Okay, so I don't think there's any relevancy. Never, ever, maybe, but certainly it wasn't established in this case. No relevancy whatsoever.
Why isn't the same true then when you turn to the argument about fault evidence? Why is that relevant?
Okay, I'll address that right now. The question isn't, is it relevant? The question is it unfairly prejudicial? And let's go through each of the facts that we established. And by the way, the sum total of our testimony on liability was 14 questions, less than 6 minutes. And we quoted it directly on page 8 and 9 of our brief. We quoted the entirety, the sum total of the liability testimony, less than 6 minutes during the trial. So let's go through the facts that we established. When the district driver stopped the vehicle, he did not put the van in park. Is that inflammatory? He did not set the emergency brake. Is that inflammatory? He did not turn the engine off. Same question. He did not take the key out of the ignition. Same question. It's on a downhill. It rolled downhill. It accelerated. Are either of those facts inflammatory? It jumped a curve crashed into her and did extensive property damage to the Warner Theater. Is any one of those facts, all of which took 6 minutes, is any one of them inflammatory such that they would constitute unfair prejudice? When a defendant decides to admit.
Counsel, I'm not going to say I disagree with your argument entirely, but it seems to take those things individually. I have a younger sister who is annoying as all get out. If I ever had a bruise, she liked to poke it multiple times, and 1 or 2 pokes didn't hurt very much. But by the time she got to 5 or 6, that started to hurt a whole lot. Could you see a scenario where inflammation over time rises with each additional fact coming in when they've already admitted the liability on this?
Well, okay, Judge Howard, let's take the, hypothetically, maybe, okay, hypothetically, not here, hypothetically. But as one of the members of the court pointed out, in the argument in opening and closing, it really had to do with timeliness. I mean, it's been over 6 years now. It was over 4.5 years when we got to trial, when they stipulated to liability. Remember, this crash was witnessed by a DC police officer who was parked at the corner, watched the van go by and crash in. They knew immediately that they were at fault. They fired the guy. They went through administrative hearings because he was fighting for his job. They put on all that testimony. They never, ever admitted. We had to go through extensive discovery.
Why is any of this relevant to the amount of damages? You're now beating the drum that you beat in front of the jury.
Okay.
They disrespected her. They didn't accept her responsibility. They're not sincere. It's a
Yep.
last minute tactic. Why does that have anything to do with the amount of compensatory damages?
Well, because they're when they come in and try to say, look, we accept responsibility, they're entitled to the context. Okay, the context of that is, wait a minute. You saw the cavalry coming over the hill. You saw the jury coming in the courtroom and you admit liability when for 4.5 years you didn't do that. It's not inflammatory. It's designed to rebut the situation. Look, we accept responsibility. When the defendant
It's
accepts,
designed to punish.
it's not designed to
You're
punish.
trying to inflame the jury to punish the district.
I disagree. It's designed to rebut the assumption that they've been responsible all along. That's all it's designed for, Your Honor. It's not designed to punish them. It's to put context. Otherwise, the jury thinks, well, they've admitted it for 5 years. What? She's just here for money. That's the context of it. And it happens all the time in liability cases in stipulated liability cases where it's when the cavalry's coming in, they do that. And we are entitled to say, well, wait a minute. You're not really as nice as you're trying to make it. You just agreed now because the jury's coming into courtroom. Okay, so it's not designed to punish them. It's designed to put it in context. And when a defendant admits liability, does that entitle them to half truths with the jury? Does that mean that they can put in a lifeless stipulation of liability? When Judge Rigsby said, that is not an accurate statement of the facts, work with the plaintiffs to come up with a joint proposal, we immediately gave them a proposal, 25 words. They refused to discuss it with us. It was, you either take our proposal or we're not even going to edit yours. They wouldn't even look at it. They wouldn't talk to it. We tried, we put one in there that we would have saved 6 minutes of time. Okay, we would have saved 6 minutes of time in the end because of that. But they wouldn't negotiate on it. They literally refused to negotiate. And that's why we put on 6 minutes of testimony. And it's not designed to punish.
Is it true that the evidence of fault came in only through Mr. Cancelosi?
Yes.
And no other witness?
Correct.
The DC police officer who witnessed the thing?
No, he
did
wasn't
not
necessary to be
testify.
called. It was literally 6 minutes of trial testimony. There was some cross-examination, but our direct proof was less than 6 minutes, 14 questions, and we've included it there. So to summarize that issue, when you look at each one of the facts, there's nothing inflammatory. There's nothing unfairly prejudicial. In fact, it does put context for the jury to understand, because remember, what was the district's argument here? They were minimizing, right? They were minimizing her injuries. She has 3 fractured vertebrae. If you, the illustration, which comes directly from the CT, is in our brief somewhere. I won't waste time looking for it. But it's on page 12. That's the actual CT. Okay, you can see they're smashed. That's lifelong. She had 5 years of living with it through the time of trial and 37-year life expectancy. She has pain every single day. And in the brief, they say, yeah, well, when she wakes up every day, it's only a 2. That's true. But by the end of the day, it's a 5, a 6, a 7 every single day. So let's talk about the verdict form. It cannot possibly be an abuse of discretion for the court to use the precise language. I know, Judge Fisher, earlier you said that the verdict form tracked to some extent the jury instruction. It's verbatim. Literally every word is verbatim from the jury instruction. It's inconceivable that a trial judge could abuse his or her discretion by using the words of the jury instruction that has been in use for 50 years, unaltered in those respects, in the respects that they went in. And then, the jury carefully consider, I mean, they put some zeros on there. Okay, this is not a runaway jury. They put some zeros in there for certain things. So they considered this.
It's hard for me to come up with an explanation of why these categories are not overlapping. Too many negatives in my statement or question, but it seems to me that there definitely is overlap, and the law seems to be clear that we don't permit double recovery. Why isn't this verdict form vulnerable, defective, because of the overlap?
So here's what I would say, Your Honor. What you're saying is that the jury instructions, which, as you know, has this court's imprimatur, they don't get passed without this court's blessing, is that the jury instructions have overlapping on them, and maybe we should address that. Okay, but it can't be an abuse of discretion for the trial court to use the very instructions that this court has passed. So
It might be an abuse of discretion to give that instruction and use a verdict form without adding an admonition of you cannot compensate 2 times for the same pain, 2 times for the same emotional distress.
well, I don't think that's necessary. I think that gets into argument. I don't think that's incumbent on the trial judge. I'm not aware of well, I'm going to say hundreds of trials that I've tried in this jurisdiction where a court has ever said that and never been reversed for it. And so I would say this, that if we accept the premise of your argument, Judge Fisher, then it's really a question of the jury instructions, okay? It's not, but they've been blessed by this court for years and years and years, and in decision after decision after decision. So Judge Rigsby didn't abuse his discretion by relying upon the history of the court having blessed this. So I don't think there's any way that on the facts of this case, it can be fairly said that he abused his discretion in that regard. Thank you very much.
Thank you. I forgot to listen when you were pronouncing your last name, Leach. Leach. Okay, Mr. Leach, we'll give you 3 minutes.
Thank you so much, Your Honor. Just a few points. Wanted to just clarify with Lawson, this court can read for itself what the court's analysis was at page 331. It was part of the court's analysis. We are not claiming it was a holding. It undergirds the logic of the decision in that case. When it comes to Judge Fisher, you had mentioned, yes, absolutely. The closing and opening arguments were about punishment. You also noted that there is overlap in the verdict form. It did invite duplicative recovery. Just merging the jury instruction onto the verdict form can absolutely be abuse of discretion. The only case we found on this is the Illinois Supreme Court decision in Powers, where a standard pattern jury instruction was put onto a verdict form, and the court there held it was abuse of discretion because the same reason here, overlapping categories of damages. We cited that case in our opening brief. Plaintiffs never responded. The court can take it under consideration. Additionally, it was to clarify a few things. The jury instructions are not literally verbatim on the verdict form. The jury instructions are in some ways even a bit more streamlined than the overlapping categories on the damages, and the court can see for itself on that. Judge Rigsby, as far as I just looked at the transcript, never said that our stipulation was inaccurate. He said that we should go back and discuss with the plaintiffs, which we did. There were further discussions. They were not fruitful. We ultimately were not able to reach a stipulation, but the plaintiffs accepted our standing objection. And my friend, when he was talking about the liability evidence, never once attempted to defend the training testimony. At no point in their brief or argument on appeal or in the lower court have they ever addressed Curry or explained how the training testimony was relevant. And prejudice with that evidence is not a stopwatch test. There may have been 6 minutes with Cancelosi on those issues, but they infected the entire trial because they were used and emphasized in closing argument. And this is a J476 to 77, where they brought up again the fact that this guy wasn't properly trained. My friend used the cavalry metaphor again, which he used with the jury. He told the jury, you're the cavalry, you're coming over the hill, the district are the bad guys. This is about, triggering punitive instincts in the jury. Judge Howard, you mentioned about relevance being a potential ground for reversal. I think it absolutely is. When we show that this was an abuse of discretion, I think we've shown that it was prejudicial error. And then additionally, to go back to my point earlier about the verdict form, I think when you look at all three of these errors together, there isn't a way to fairly read this record to not come away with the sense that these three errors, at least in total, had an appreciable effect on the verdict. And we ask that you reverse and remand for a new trial. Thank you.
Thank you very much. Thanks to both counsel for your arguments today. The case will be submitted. Second case on this morning's calendar is number 22 TX 610, Audrey Wong versus District of Columbia. Whenever you're ready, Mr. Schwartz.
Good morning, Your Honors. May it please the court, I'm Frederick Schwartz representing Ms. Long again. And I've reserved 2 minutes for rebuttal. This to me seemed like a very simple case. The district is asking my client years before her property becomes vacant to declare it's vacant, which would be against the statute. And then it's saying that there's no remedy available for that the council actually intended that she should not have what was a very efficient way of dealing with this new part of the statute. In terms of the vacant property statute, it goes back more than 100 years. And as it's developed with two branches. The first branch is the what I call the trash removal portion. And in the trash removal portion, the fact that it's a detriment to the environment, it's a detriment to health, it's a detriment to every possible way that that we survive in the District of Columbia. And that's remained the same. And that has nothing to do with our discussion this morning. When it became vacant, my client kept it. Actually, my client cleaned it up and has kept it
perfect shape and not in violation of the statute. What we're talking about is the second element, which has come on much more recently, and I've submitted the legislative history, and that is that for economic and other reasons, we don't want the district, or the district doesn't want landlords and people who own property to warehouse them. They want it to be turned into productive use, to hire people, to have a significant tax base, and for all sorts of reasons. So there's nothing wrong with that principle. But what the council did, and this is the job of the council, what the council did is that they said there are instances where, in fact, it isn't appropriate, it isn't fair, it isn't right for the voters for us to say property can remain vacant.
But why isn't it the case, or what is wrong with saying that, you know, this simply does not apply to your client's somewhat unusual situation?
Well, the overwhelming requirement does apply to my client. The overwhelming requirement is that she must, if the property is vacant, she must hold in reserve the requirements of the statute. But there are temporary exemptions and they can be renewed. As long as she's in the case she's in, she's subject to an exemption, but she is always subject to the statute itself. And she's always subject to the principle too, Judge with. It's important that you have a vacant property statute as it is.
I'll accept that, but we're talking about exemptions, and is your argument that she automatically gets this exemption? That doesn't seem on its face and in the plain language to apply to her situation.
Well, she is a strange exception, but the statute, in fact, is clear as to what her duty is. The statute is clear that when the property becomes vacant, which it did 2 years after she sold it, or 3 years after she sold it, when the property becomes vacant, then you have to declare it's vacant.
Counsel, I think where the real crux is how do we get around the specific statutory language that links that exemption to 2 years following the initial offer of sale or advertisement of sale for a commercial building?
Well, Judge Howard, Judge Beckwith, Judge Fisher, and probably you have written decisions where you said that if the statute is unreasonable or doesn't make any sense or is detrimental rather than helpful, I've cited them. They're the Judge Beckwith wrote a long opinion in Expedia recently, where she pointed out that that if a statute's unreasonable, then we don't have a plain reading. The trouble in the tax court is that she ignored that.
There's a difference between saying the council did a poor job. It's not reasonable because they could have done much better. And saying that the plain language interpretation leads to an absurd result that they did not intend. You seem to be arguing they should have done better. They ought to write a better statute.
No, Your Honor. That is almost the opposite, Judge Fisher, than what I'm arguing. What I'm arguing is the statute is not meant. There are elements in the circumstances which are highly unusual. I mean, when Ms. Wong entered into the contract, it said time is of the essence. We need to move ahead, and they did move ahead, but they ran into problems. So, but you've written opinions and I've cited them, Colbert. And in Colbert, you said exactly what I'm saying. What you said is, we have statutes. It's our job to interpret the statute. And when we run into a reading of the statute, which is unreasonable or inappropriate, or somehow we sense it wasn't meant by the council, that in the circumstances, then we can interpret it to include those elements of this of the statutory language which are appropriate, and we can in a way modify the language or reinterpret the language to say that in
Maybe
fact,
I should have written an opinion that says that, but I don't think I did.
well, Colbert, I think that's what Colbert said.
Well,
You-
counsel, help me. If we don't accept the premise that she has this time paradox issue of needing to register before, to know without knowing and needing to register ahead of time, how do we get to the absurd result?
Okay, you get to this absurd, well, first of all, the statute says that when it becomes vacant, she will register it. That's
Understood.
what the statute says, and that's what she did. So that's one way of getting around it, just by the plain statutory language. But the 2-year limitation runs afoul of that particular statutory duty. She cannot register her property as vacant if it isn't vacant. I mean, that would seem to be the circumstance that this court should reach. And in answer to your question, it said when she should do it. And she did it when the statute said she should do it. And the fact that the exemption is not there, it is merely cause for judicial interpretation. I think that's the way I would say, Judge Howard. For example, when you had all these agencies coming to you when you were an ALJ, and they came to you and they made their argument, and you were able to look at their argument and determine precisely what should have occurred based on the statutory language. And that's the same thing. And I wish I had the full sight of Colbert. I do have the language. I think you were just on the court. You may have not actually written Colbert, but you were part of the division.
We can look it up.
Okay. And in any event, I cite it. So
So
Perhaps-
counsel, we also have precedent saying that when we're looking at tax cases, we're looking at tax laws, we should construe them very narrowly. And one of the cases that you cited to help your client was the BAE Systems Enterprise Systems Incorporated, a rather redundant name, company name case. And I saw a little bit of distinction there. I wonder if you could address for me. Here, it seems like this is an exemption to a punitive statute or a punitive piece of a statute. And there, that high technology corridor exemption seemed like a benefit brought in to draw business that we should interpret more expansively. Why should we treat these two situations, that situation and this one similarly, and rewrite the statute, so to speak?
well, because in that case, which was a fairly recent case, as you know, in that case, the statutory language was clear, and it involved rewriting the statutory language and the statutory purpose. In other words, they put in that that particular provision, and I believe it related to where the property was actually located and the number of people they employed and how the number that they employed. And they stretched the boundaries. I'm not asking this court to stretch the boundaries or to outguess outguess the council. Judge Beckwith had the Expedia case fairly recently. And well, everything's fairly
Yeah.
recent with me. In any event,
Seems like 10 years ago, but I'm not sure.
in any event, you wrote, and if I would have been familiar with the case, I might have even cited that. I may have even cited it. You wrote about how you have to look at the statute. And when you look at the statute, you can't outguess the council. But when the council has a provision which is unreasonable, and I think probably every member of this court has dealt with statutes which are unreasonable or interpretations are unreasonable, then, or circumstances which were clearly not included, then you have to do what judges do. In the case that Judge Howard mentioned, the language is clear. They thought, I think in the opinion, they even went so far as to say, this doesn't make any sense and the council shouldn't, we don't know why the council did this, but they did it. In this case, it was impossible for my client to comply. And
Mr. Schwartz, let me ask you to interpret the 2-year limitation in light of the following scenario. Let's assume your client has an operating restaurant in the premises. Things are going good, but she decides she wants to sell. So she puts a for sale sign on the front window. Restaurant keeps operating and operating. And 1.5 years after the for sale sign goes up, the restaurant owner says, I'm out of here. I can't take this anymore. The uncertainty, I'm moving someplace else. And that's 1.5 years after the for sale sign goes up. When does the 2-year exemption start to run?
well, the 2-year exemption starts to run when in fact it becomes vacant, because the statutory requirement is absolutely clear. When it becomes vacant, you go to the district and you say, I'm registering this as a vacant building.
But let's look at the statutory language of the exemption. It says the time period for sale or rent shall not exceed 2 years from the initial listing or advertisement of sale in the case of a commercial building. So it seems to be triggered not by the fact that the premises become vacant, but by the decision to sell them, the listing, the public manifestation of the desire to sell.
Well, as I interpret the statute, Judge Fisher, what it says is that when you decide to sell, or when you decide to put it on the market, that is the period where if it's vacant, then when it's vacant, that is the period where 2 years count. And that is the period where 2 years counted for her. But if in fact I put up a notice to sell, and the restaurant's still there, I can't say it's vacant. I can't go to the district and say, sometime in the future, if I'm really lucky and I can sell this and get out, then I think it's going to become vacant. And therefore, the exemption, I get a 2-year exemption, and then there are a few more exemptions if there are unusual circumstances. But in fact, in your situation, if she puts it up for sale and it's vacant, which is a requirement of the statute, then in fact, she has to do it. But if it isn't vacant, if the deal here, and I think Judge Beckwith had it and Judge Howard at Salpini, the deal here was you can keep the restaurant going till we need it because it pays its taxes and it's worth money and you're getting rent and time is of the essence. So it's good for everybody. And the property is safe because somebody's there. And then it changed. But in your example, in your hypothetical, Judge Fisher, if the restaurant never left, if the restaurant was still there until doomsday when they finally sell it or go through the transaction, it's been sold, until doomsday, she has no obligation to say it's vacant. It's vacant when it's vacant. I hope I didn't sound like a political candidate. And that is the fact. But you know, I've cited the provision in the legislative history where they said, you know, this is you know, an interesting situation. And we expect the mayor to use in his or her judgment, although they said his judgment, we invited the mayor to use some discretion here. And they needed to make a regulation relating to the discretion, so they outlined what the discretion was. And then they put it in one of the revisions of the statute. But the answer to you is you have to look at it in terms of duties. You can't violate the statute. You can't say this is vacant when it's not vacant. So then the question is, when it's vacant, I mean, you can't say it's or when it's vacant, you can't also say, you know, it's for sale when it isn't for sale. You can only say the sale applies when two things occur. One, it's vacant, and two, it's for sale. And then the 2-year applies. And that seems to be the intent of the statute.
Thank
And-
you, Mr. Schwartz. We have your argument and you've run out of time, but we'll give you some time for rebuttal. And
Thank you. I think I've reserved 2 minutes.
we'll give you at least 2. Thank you.
Morning, and may it please the court. Sean Frazzetti on behalf of the district. The district is not asking that Ms. Wong register her property before it became vacant. It's undisputed that her property became vacant on July 1st, 2018. She was required to register it as vacant within 30 days of that date. At that time, the building would also be placed on the list of vacant buildings and subjected to a heightened tax rate unless it qualified for one of the exemptions listed in 42-313106B. Ms. Wong did request one of those exemptions, the renter sale exemption, but the DCRA properly determined that she simply didn't qualify for the exemption based on its unambiguous text. In her brief, Ms. Wong has also raised for the first time that she should have received a different exemption, the economic hardship exemption, but she's forfeited that exemption, and in any event, she does not qualify for it based on this record. So I'll take the 2 exemptions in turn. First, the renter sale exemption, as Your Honor quoted earlier, applies to a property owner who is actively seeking in good faith to rent or sell their property, but the exemption cannot exceed 2 years from the initial offer, listing, or advertisement for sale in the case of commercial buildings.
So what is the reasoning underlying an interpretation that, as Ms. Wong says, makes it impossible for her to qualify for this exemption? You know, what's the main reason for your interpretation?
Well, our main reason for our interpretation is just the plain text. The council decided that the clock starts ticking the first time someone offers the property for sale.
A lot of times we'll see, yeah, the plain text, but we still want to think, why would this person be excluded when you kind of think maybe for some reasons they would have a way of fitting into the exemption?
Your Honor, I think that the overall purpose of the vacant property tax scheme is to make sure that properties are not vacant. We would like them to be filled and used to the best of the property's ability and or the property owner's ability. And in this case, we would like to cap the time that a rent or sale exemption might apply, because we want renting and selling to go expediently, to go quickly. If someone puts their building on the market and it's a price too high, or there's some other term of offer that is unreasonable to the market, then we don't want them to be able to just get away with not having to pay a vacant property tax just because they place an unreasonable offer out there. And so by capping it at 2 years from the initial offer, even if it's not vacant at that time, we're trying to make sure that property owners are actually trying to sell their property.
Well, counsel, I'm not quite sure about the practical effect here, though. So initially, if someone had it vacant, they'd have 2 years for it to be vacant before they started getting harmed by having to pay this extra tax that your opposing counsel categorizes as 500% more than what they would normally pay. I'm not sure city council was thinking about this bizarre scenario. I mean, because the effect here is that this person had essentially 0 days. I mean, the property was compliant and occupied for years before it went into effect. So what is statute aside, and I don't disagree with you about what the language says at all. What justifies such a vast difference in effect?
Well, Your Honor, I think that here we don't want contracts exactly like Ms. Wong's. We don't want to have a situation where someone puts their building for sale and then is contractually obligated to leave it vacant for a period of time. And so they shouldn't get the benefit of this exemption that is only supposed to last for
Doesn't
2
the higher tax for vacant buildings take care of that after the 2 years, just like it would for any other taxpayer?
It may, Your Honor, but in this case, Ms. Wong put her building up for sale and did agree to sell it in 2013. So the facts here are that she had an agreement to sell and it's just been dragging on. I think that whatever purpose the council may have had here, that the facts of the case are that it clearly just falls outside of the text that the statute does provide.
Do you see somewhere in the legislative history where some of that intent you just cited to us comes from? Because as I looked at it, it was pretty ambiguous on this point. The legislative history, not necessarily the statute. And I'm very sympathetic to the idea of they don't want contracts going into perpetuity. We want productive economic use of the property. I'm just trying to wrap my mind around if it had been vacant at the start, Ms. Wong would have had 2 years, but because it wasn't vacant at the start, she has no time.
Your Honor, we are not citing any legislative history here. We don't appeal to any legislative history. We think the text of the statute settles it. The only legislative history that really does say anything on this is that they said they put a time period on the renter sale exemption to quote close a loophole. Ms. Wong cites that legislative history in her briefing. That loophole presumably was the fact that before there was a time cap, you could just leave your property on the market for any period of time and be eligible for the
No,
renter
I
sale exemption.
understand. I was asking about the specific answer you were giving me about not wanting contracts going into perpetuity, and I can see, it sounds like you're saying it's not there.
Yeah.
Tell me hypothetically, and this isn't going to be a drawn out hypothetical, but if Ms. Wong were, and I understand this to be against the rules of her agreement, but if she were to delist the property and then relist it for sale, in your view, would she then be entitled to the 2 years?
Your Honor, we think that's a harder case, but we think that the word initial must be doing some work here. It's a property owner's initial offer, listing, or advertisement for sale that triggers the 2 years. And so we think that just by delisting and then relisting, you're just getting around the initial listing there. You actually have a second listing or a third or so on. And so for the text to mean something, we think that it's only the first time the property owner lists it is how we interpret it. So based on this record, Ms. Wong put her property for sale sometime on or before July 10th, 2013. We don't know exactly when. We just know that that's when she agreed to sell it. And because simply tax year 2019 is too far removed from that offer, we believe the DCRA and then the commission afterwards in the Superior Court have all properly construed the statute and deemed her ineligible for this exemption. Turning quickly to the economic hardship exemption. This exemption is available only to property owners in extraordinary circumstances who can make a quote showing of substantial undue economic hardship. Ms. Wong is not eligible for this because she's forfeited every step of the way. At supplemental appendix 19, you can see that she only ever requested the renter sale exemption in front of the DCRA. At supplemental appendix 16, you can see that she only asked the commission on her appeal to judge the renter sale exemption. The same is in her petition to the Superior Court. That's at appendix 86. It's in her opposition for the summary judgment, and it's in the hearing for summary judgment. The
Oh.
only
I was going to ask you if she can go back and seek the hardship exemption, but now you seem to be arguing on the merits that she doesn't warrant it.
I don't think there's any reason for this court to let her go back at this point, Your Honor. She's had time to actually make a proffer of any evidence that she's facing hardship, and she has never taken the opportunity to do so. She's just made allegations that a contract that she signed and that she agreed to is financially burdensome to her, but she's not made any showing that that is actually true. There's nothing that this court can go off of to really decide whether she's facing a hardship such that it should be returned or remanded for her to make that showing. She can claim the hardship now for this tax year if she is facing a hardship. She's welcome to petition the DCRA for the exemption. She's welcome to update the
Well,
OTR.
Counsel, that also begs somewhat of a question. It appeared to me in your briefing that DC now concedes administrative exhaustion for the years beyond 2019. And so not to pull you away from your main argument here you're making, but it raised the question for me, what's the practical effect of that for us? What does DC think should happen there? Is it that it needs to go back either to the administrative process or the trial court to determine what, if any, claims have been preserved or made for those tax years? Does Ms. Wong need an opportunity to make some for that time period? Or is your stance essentially, as you were just saying here, it's available for this tax year forward, but kind of nothing before?
A couple of responses to that, Your Honor. First, for the purposes of this appeal, we did concede that she is exhausted those. Upon further reflection, we actually believe that our original position in the Superior Court is correct. You have to re-register your property and reclaim exemptions yearly. That's in 42-313107. And so Ms. Wong did have opportunities for tax year 2020 and onward to raise exemption claims to register a property as vacant. You can also petition the OTR at any time to reclassify your property from class 3 to something else if there's been a change in circumstances. So just for the purposes of getting the law right, we want to make clear that we actually think that our concession was incorrect legally, but we understand that we've conceded that here. In terms of the practical effect for Ms. Wong, like I said, she's welcome to go to OTR today and tell them my property is not actually a class 3 property, it's a class 2 property, and that's because of my undue economic hardship. She has not done that to our knowledge. There's been no claim that she's done that. And I don't think that she's made any showing to this court to send it back to them to instruct them to do that or anything in that matter. Because neither the renter sale exemption nor the undue economic hardship exemption apply to Ms. Wong based on their unambiguous terms, we think that this court should affirm the grant of summary judgment below. Unless your honors have any further questions, then I'll happily give back the rest of my time.
Thank you very much. Mr. Schwartz, we will give you 3 minutes.
Thank you, Your Honor. First of all, the property was sold. And secondly, the district now argues, although they've gone through the entire administrative process and through a board, they now argue, well, she had other remedies. She could have asked for a hardship exemption or an economic exemption, but the answer is no, she couldn't. She could only ask for that after she went through the easier 2-year exemption period. And then she could go and say 2 years are up.
Why?
And when she didn't get the right to do that, she couldn't, in essence, say, well, I flubbed the I don't know anything test, but I still have a hardship because they said, why didn't you ask for a 2-year exemption. She couldn't have asked for a 2-year exemption when the property was sold.
Why
and it-
couldn't she have argued in the alternative? Why
She-
couldn't she have said, I want the 2-year exemption, or in the alternative, if I don't get that, this is going to produce an undue economic hardship?
Because Judge Hart, that's not the way the system worked. The way the system worked under the agency is you apply, you check the exemption that's the most appropriate exemption. And then it gets acted on, and then it gets acted on by the review people. And it was what used to be DCRA before their divorce. And then it's sent to the board that's in charge of assessments. And by the time it got to the board that was in charge of assessments, that's when they dealt with the issue that we were trying to raise all along and never got involved. So at that point, it was more appropriate. I decided based upon the statute that I needed to proceed and have a finalized answer on the 2 years. And then I could go and say, we've lost on 2 years. Now we have a hardship, because they didn't have a hardship while there was still a 2-year period pending. And the fact that this has taken a long time to get to this court and get it resolved does not alter that fact.
When you say that the property was sold, which you started your rebuttal with, what do you mean?
Well,
Are you saying the property is gone and out of her hands and owned by someone else?
the property was sold because she had no more rights in that property. And it was waiting upon a process where you, in essence, exchange deals and pay the district money. But she had no right to back out of it, as I pointed out in my papers. She was stuck. She was stuck in a situation that, despite what the tax court said, was not her fault. And she spent
So
her
why
time.
is her remedy not against her, the buyer and the deal?
No, he bought it. He's gone before the BCA and say, this is my contract property. He has rights in it. He has all the rights in it. He has the right to tell her what to do and not to do. And he exercised those. And as you found in Salpini, and consequently, she was stuck. And so I took on her behalf what I thought was the most appropriate course to take. But I know that I could not have gotten a hardship exemption by going back and saying, well, you've denied one. Now it's a hardship, because it wasn't a hardship as long as I was pursuing my argument that she couldn't be asked to do the impossible. And when it was possible to do it, she did it. And my time is up.
Thank you
Thank
very
you.
much, Mr. Schwartz, for your arguments today. Thank you, Mr. Frazzetti, for your arguments. The case will be submitted. The last case on this morning's argument is number 23 CM 10, Michael M. Hawkins versus United States. Morning, whenever you're ready.
Good morning, your honors. Lisa Resnikoff for appellant Michael Hawkins. May it please the court. I'd like to start by explaining why the hearing court made a mistake, because the government possessed and through its untimely turnover suppressed exculpatory evidence from the defense in violation of Mr. Hawkins' right to due process under Brady. So the hearing court found that the government didn't possess a surveillance video that was in the hands of a building across the street from where this altercation took place. However, what defense counsel at trial and on appeal are arguing that, in fact, the government did possess exculpatory video, which was the body worn camera of the officers. And on that video, a woman in a security guard uniform comes up and says, I looked at the time period that the complainant, who's standing right there, told me to, and I saw her come around and I didn't see anyone get out of the car. Now, on its face, that's exculpatory, because what the complainant has told the police is that Mr. Hawkins got out of his car and threatened her and brandished a weapon. And
That evidence was disclosed 2 months before trial, and it was shared with the trial court. So your argument seems to be that there was better evidence in the form of the surveillance video.
well, what the video that the government possessed revealed was that there was an eyewitness to this event who saw on a video from the building across the street that there was no crime committed. And so by the time the government turned over this video that it took itself, the defense was unable to retrieve the other evidence.
I understand that, but let me try again with my question. You explained why the statement of the security guard on the body worn camera was helpful to your client. We'll call it exculpatory. That evidence was presented to the trial court.
Yes.
It was revealed to your client 2 months before trial. So what is the surveillance video? Do you think it would have been more convincing? It was better evidence?
Well, if it, according to this witness who said, I saw the video and this crime didn't take place, yes, it would have been very good evidence for the defense to have.
But she said that. There is evidence to that effect.
She did, but the trial court also said, I'm not gonna discredit someone else, the complainant's version based on this video because she's not under cross-examination and we don't have the video. So
It was no surprise to your client that there might have been video that captured
Correct.
these events. They went and looked and inquired and came up cold. So explain to me what the body worn camera added to the perception that there might be video out there.
Sure. So before the defense receives this body worn camera, they do make an investigation attempt. They inquire with the buildings. The building's response is that, and this is in the first week of this case. And the building's response is, I've talked with my security team and we don't have anything helpful. Now, 48 days later, or a month and a half later, they see, oh, but wait, you do have video, because here's a person telling me that I watched this video of this incident take place and now we can't get it. And the government knows that surveillance cameras have expiration dates because they know this, they've argued this, in court before. So by not turning it over in time for the defense to use this information, it's the same as, withholding any other exculpatory information and didn't have the chance to get that evidence. And then,
So your argument seems to depend upon the assumption that the video would have helped your client.
at this point, we can only assume it does because there was a person saying that she watched the video and it didn't show any crime being committed. But I do think that regardless, at this point, once the government knew that there was an exculpatory statement that it had on this video, it needed to disclose it to the defense. And the defense asked for this very clearly in its Rosser letter. It's in the record. It was bolded under Brady requests. And I put it in my reply brief, any statements by any witnesses that contradicts the complainant. And unfortunately, because the hearing court did not perceive this evidence as being within the government's possession and the trial court refused to re-examine this ruling, there's no evidence as to why this video wasn't disclosed.
Do you have any case law? This is an unusual case because I don't know when in Superior Court, after the Rosser letter is sent, how long after that true Brady evidence is actually turned over, but this is turned over well before trial, which is different from Tyree Miller, where, you know, it was turned over the night before trial started. You know, do you have any case law that gets us closer to this situation, or are you just depending on the
Well-
unusual, you know, this is obviously exculpatory, and yes, they did disclose it, but it was just not in time for effective use?
I think Copeland and Askew get a little bit closer, but again, it's a little bit different because those were cameras that were controlled by the district.
Right.
I've been trying to think of like a great analogy for this case, and I think the best one I could come up with was when I talked about in my reply brief about the Weems case. And in that case, the government, you know, was questioned whether they didn't turn over video that was also, you know, could have been exculpatory to the client. But in this case, there's someone on the video that's exculpatory, saying something exculpatory. And, you know, that also ties into why this email that came up after the police officer's testimony, that also wasn't disclosed to the defense.
One of the things we might have to do if we grant you relief is try to articulate a rule of law that says how quickly the government has to turn over something in these odd circumstances. How would you articulate a rule that can be reasonably applied in future cases?
Sure. Well, I think if it comes down to something exculpatory on a body worn camera, I think the rule should be that it has to be disclosed. You know, there already is a rule that it has to be helpful. But if we're rewriting the rule, you know, at least within 30 days of receipt of, you know, of taking the video, because by then, if there is indications of other exculpatory information, it can be retrieved.
I don't see that sort of a rule in Rule 16, which governs discovery. I haven't seen such a rule in the Brady cases I've read. So where do you come up with
Well, it has
30
to be-
days?
Well, it has to be available for the defense to make use of. So in this case, the defense wasn't able to use any of the exculpatory information in its case. And that's exactly what Brady and Rule 16 are designed to prevent. You know, if there's evidence out there showing that this person is innocent, which my client has always maintained, you know, and the government's hiding it until, oops, it's, you know, surveillance is gone now. And as it turns out, the security guard doesn't work here anymore, you know. And another thing about these body worn cameras is, of course, they're under protective order. So it wasn't even like the defense could go out with her picture and try and canvass for her. They're not allowed to disclose anything off the camera footage.
You use the word hide. Are you claiming, you know, I thought that the argument you were making sort of like, we don't need the Arizona versus Youngblood or whatever bad faith showing here. Whoops. Because this is a Brady violation that's causing the unavailability. But you use the word hide. What is your take on the government's, you know?
I mean, it's really impossible to say. There's no reason given as to why this wasn't turned over sooner. There was nothing stopping the government from doing it right away.
And what do we make of, what is the relevance of sort of the government's description of this, you know, the security guards' comments that, you know, we really don't know if she was looking at the right video or the right time, you know, whether it's even the right day or something, you know, what is the relevance of those sorts of things? We actually do not know what it would show.
Well, she does say when she's speaking to the complainant, I saw you come around, I saw your car. And so there is some evidence within the video itself that she was looking at the correct portion.
But do you think this is that just we have to, it looks like it might be relevant, or, what is our standard here for?
I think the standard is, it's from the defense perspective, and from the defense perspective, this was incredibly helpful and exculpatory information, and
But
the
it's
government.
hard to figure out. You say the Brady evidence is the body worn camera footage. But when we're talking about the materiality, we keep talking about the surveillance
Mhm.
footage from the street. How do we? This doesn't fit neatly into a Brady box with all of the Brady factors. What is the materiality analysis?
The materiality analysis is that this video had inside of it something helpful, like a DNA
This
sample that
video
doesn't get
meaning-
tested. The body worn camera
Okay.
video. The swab that doesn't get tested for 20 years, and then, oh, now we can't, test the DNA. Something where the evidence is not the thing itself, but it contains other things. I hope that makes a little bit of
Well, I
sense.
guess I'm wondering if, like the swab, if there were no reason to think one way or the other that it was going to be exculpatory or not, would that still be material, in a hypothetical involving a swab?
I think it would in this case, because my client has always said he's innocent and he never did anything. And he's even telling the police officers.
Well,
"I
everyone who
never got out
goes
of
to
my car."
trial is claiming they're not guilty, right?
Right, but, he's also entitled to reasonable doubt. So at this point, when the video comes in, to the defense possession, there's no reason not to take this woman at her word
I
on the
guess,
video.
I guess what I'm saying, maybe I'm wondering where the line is. Like, you have Copeland deals with one camera that's at the US Attorney's Office and says, we have no idea if it was even facing the right way. That may be an agency affiliated with the government,
Mhm.
literally. But we're not viewing that as relevant because we don't know what it says. So here, I'm guess my question to you is how, we don't know here either, but is your argument that we know enough? We know enough to think this is, does the surveillance video just have to be useful? Something we already have the exculpatory part and it doesn't necessarily have to be followed through on?
I think if the camera was in the government's possession, it would be a different scenario. But because it's in private possession, the materiality is that it leads the defense else to other evidence. And that evidence, which, it's sort of like a proffer. She's saying, I saw this, there was no crime. So the defense can't make use of that, can't prepare for its witnesses and defense and investigation until really this comes up. There's nothing to subpoena for the defense until it gets this body worn camera video.
So in those 60 days, counsel, was the defense able to look and see where exactly were cameras oriented from that surveillance setup?
Yes, it was pointing at the location, yes.
And what was the search like for the security guard who was on the body worn camera?
So,
It wasn't completely clear to me from the record.
sure. So the search for the security guard was that there was subpoenas that were given, I believe, after the video comes up to the security company, but she wasn't working there anymore. And so it was complicated without her name, because there's no evidence that was turned over that the police officer that interviewed this woman ever took down any of her information. And then there was no, we couldn't use her face to go canvassing again because of the protective disclosures. There really wasn't much to be done other than sending out this.
So the security company wasn't able to use the day of the interview and the site of it to identify who the employee was?
My understanding is that it was not responded to. I don't have a full information.
I mean, the most that I think is in the record comes out in the hearing before Judge Curie, where defense counsel
Yeah,
kind of goes through all of the efforts, but what about the email that the officer sent to the detective, there is a name and a telephone number on that. It's, I think it was referring to the,
That was the detectives, I think.
oh, I thought it said like Sue, and the telephone number. I thought it might have been the person who had the blurry video, if you
Mhm.
know what I mean. That was not helpful on the same side of the street as where the
Well, again,
cars-
they didn't get that email until after this officer had already testified, and this didn't even come up until after cross-examination.
Yeah.
So at that point, absolutely, that information was Rule 16 in Jenks, and, there was no ruling on that.
Let me ask you more about the email. Are you still arguing that you were entitled to some sort of sanctions because the email was turned over so late?
Yes,
And explain that to me. As I read the transcript, your client's counsel says, well, let's pursue the video, let's pursue the email. And depending on when I get it and what it shows, we may have to take further steps, something like that.
mhm,
Then the email is produced, counsel reads it into the record, and he says, I have no follow-up.
mhm.
That, and when I look at the content of the email, it doesn't reveal anything that defense counsel didn't already know. So why are you entitled to sanctions because of the email?
Well, the email, first of all, defense counsel, after this email, this was like the last thing that happened, and then says, I know that there's a bunch of motions pending before the court. How do you want to proceed? Because this was also part of a suppression hearing. And so the focus was a little bit shifted, but I would say that the surprise of receiving this email showed that counsel perhaps wasn't able to use it as effectively in his cross-examination. He was in fact foreclosed from asking more about this investigation that the police were doing.
I don't
So-
understand foreclosed. It looks like he had the opportunity to ask the court to recall Officer Ack for cross-examination. He had the opportunity to ask the court to call him back for defense direct examination, and he said, I got nothing. I have no follow-up. So I don't understand why it was foreclosed.
Well, I think that once he had already asked on cross-examination, didn't you say, they should have done this already, picking up the surveillance camera, and that was objected to and sustained? I don't think off the top of his head, he could have formulated this. And I think this speaks to why this information should have been turned over sooner, because
But it was turned over, and after it was turned over, he said, I have no follow-up. So I'm not understanding your argument.
I think counsel was focused on, had made this motion for suppression, had made this motion for sanctions. And I think upon receiving the information, perhaps couldn't use it as effectively as he needed to. And even though he did receive it, this was well after he should have received this email. And again, because no one ever questioned the government, is there any more emails that perhaps are missing? How the government did or did not pick up the surveillance, go after the surveillance video on its own, never really came up at trial, unfortunately. Because none of the trial courts recognized that, oh, we do need to look into this a little deeper. So there just isn't a lot of information on the record about it.
And was that limitation at trial mostly because Judge Oken didn't want to revisit Judge Keary's?
Correct,
Even after this new email?
Correct.
came out?
correct. I think my time is up.
Okay, we will give you a couple
Thank you.
minutes on rebuttal. We'll hear from the government.
Good morning. May it please the court, David Sable on behalf of the United States. The trial court did not clear error in finding that the government turned over the body worn camera in sufficient time for the defense to make effective use of it. There are a couple of reasons for that. The court's already explored it. One is the timing. It's 8 weeks before trial, 6 weeks after presentment. The second
Well,
thing.
I'm sorry, can I jump in and ask you
Sure.
about the timing? So the, do you agree that this body worn camera was requested by the defense?
Yes,
And would the government, you know, basically the day that after it was requested, have knowledge that body worn camera showed something exculpatory, something helpful to the defense?
well, you can impute that maybe, but I mean, generally speaking, we get the consent order on the books. We do try to push out the body worn. In this case, it wasn't pushed out right away. Sometimes that's the record doesn't tell us why it wasn't turned over in this case. But if you can assume, which I'm sure wasn't the case, that the misdemeanor assistant looked at the body worn the next day and found this piece of information, which was impeaching of both the defendant and the victim. Then yes, we would be trying, I agree with you. This is something that we should be turning over. It's not material, it's not suppressed, but it's impeaching of what the victim said.
So do you-
potentially.
Do you think it's like all of our cases, you know, talking about the importance of Brady being turned over timely? And timely means in time to use, right? In time to make effective
Yes.
use of. So is the destruction of the surveillance video that the security guard is talking about on the body worn camera relevant to the government's obligation, Brady obligation?
It's part of the suppression inquiry. The suppression, obviously, you know, there's two kinds of Brady that the court looks at. One is failure to turn over, and the other is turning things over late. So I would suggest, I think we'd be looking at this through the suppression inquiry. So is it impeaching or exculpatory? Okay, let's say that it is, because it does have some modest impeachment value. It's looked at in a certain way, although I'll argue to you that it really isn't. But nonetheless, let's say, yes, we should be turning it over. And then secondly, suppression. Did the defense receive it in time to make effective use of it? And then, of course, it has to be material in terms of the context of the other evidence. So let's just talk for a minute about what this evidence does show and what Judge Curie and Judge Oken found that it showed. Judge Curie found, based on the proffer, and she didn't get to look at the body worn, that it was speculative what this video showed. And that's why she denied the Brady motion pretrial. Then it goes to Judge Oken. He looks at it. He lets it in as substantive evidence at trial. And he says in his factual findings, where he's finding the defendant guilty, he says, look, basically this is inconsequential. He said, it contradicts the defendant, it contradicts the victim. He says, basically, both people say somebody got out of the car. The victim, and she says, I didn't see anybody get out of a car, get back into the car.
But the government has the burden to, you know, provide proof beyond a reasonable doubt of all the elements against this defendant. So if the government's theory is he got out of the car and the video shows no one got, or, you know, the evidence at issue, the Brady evidence says no one got out of the car, why does it matter what the defendant's testimony was? For, you know, if he received this on time, for all we know, he wouldn't even testify. Why is that relevant to materiality?
Well, he did receive it 2 months before trial, but yes, I agree with you, Your Honor, but you have to bear in mind this. Judge Oken is the finder of fact. He looks at all this evidence together. And the reason that it matters is she's in a car, he's in a car, she's behind him. The whole idea is they're both saying there were threats. Somebody got out of a car and threatened somebody else. This whole thing could only happen if somebody gets out of the car. There can't be a crime if nobody gets out of a car, and his account and her account is nobody's getting out of a car.
Isn't it the case, I know that
So-
that's what Judge Oken said, but didn't the security guard, my understanding of what she was saying was she did observe Ms. Davis out of the car. I mean, it didn't sound like it was the way Mr. Hawkins testified she was out of the car, but she was out of the car.
Right, so what she saw was a black car and a white car. So she didn't see the defendant's car because he was in a silver car. But setting that aside for the
okay.
moment, black and
All right,
white.
Ms. Davis said it could have been
Okay.
burgundy, right?
She sees Miss Davis get out and go around the back of her car and into the building across the street. She sees Miss Davis go and look for the security video in the building across the street, the blurry video. So She says, I went back and looked at the time you told me to go look at, but it's pretty clear. And the only, I would say, all the available evidence suggests she's looking at what happened in the aftermath of the incident. She didn't look at the incident at all. And that's why Judge Oken's finding is essentially, we don't know what she was looking at. We don't know what the angle was, and we don't know what the time was. And even if it was the incident, which as a logical matter, I would submit to this court, it couldn't have been the incident.
I mean, it's your view of that is interesting because it's exactly what, all we really know is what the security guard is saying. She said, I started it at 10 o'clock. You told me that, you told me that you made the call at 10:07 or 10:08 or whatever. I started at 10 and I went beyond it. So that's the evidence, right? And I think if you want to say, I mean, just from the perspective of the defendant, right? If he really thinks I didn't get out of my car, that's pretty important evidence. And any other view of it is sort of taking into account the complaining witnesses.
Well, I think Your Honor is making a case for, hey, this is sort of interesting to me. But the fact of the matter is, we know that first of all, all this evidence came in, the evidence that was available came in. Judge Oken weighed it. He made his findings. They weren't clearly erroneous. I think that's pretty well set out in the record. That's one thing. But now you're saying, I think you're saying, oh, but what could have happened? What could we have turned up, as Judge Fisher was getting at, if we had had this information within the 30-day window? How are we supposed to approach that inquiry? What is the information that we'd look? And we have cases that are much more dramatic, like Maccabee or Terry, where there's a mis-ID that's turned over late or at trial, and the court tries to deal with the suppression inquiry. Was the defense able to make effective use? And there, the court's looking at the information was speculative. Defense made strategic decisions not to make certain uses of this evidence. And what we know in this case, first of all, so at the most, I think you can draw from what the security guard said is, there's a security camera in the parking garage that captures this crime scene. So, okay.
Why not 10 a.m., 10:07, 10:08, I went beyond? Did she not say that?
Well, she did say that, and maybe but the trial court, both courts, the motions court and the trial court, found that to the extent it did capture that, it was inconsequential. But let's set that aside for a moment. We know that they had this, we tried to get the video, they tried to get the video. I don't think, you're right, Your Honor, there was a discussion with Judge Curie about what the defense did. I don't think there's any record of a subpoena going to the parking garage. They had an opportunity to get the security guard. They didn't get the security guard. They didn't get they didn't want continuance to get the security guard. And I would submit it would be very easy to subpoena that from the video within 30 days or the security guard. That is just a little bit of legwork, could have been done. Again, I'm not really sure if I'm the defense lawyer that I want to subpoena security video, but within the 30-day window, because I'm gonna preserve it for the government. And if it's bad for me, I've hurt my client. But having said that, for whatever reason, they didn't subpoena the video. They could have subpoenaed the video. They knew the video was there. I'm not saying that that's their job to do so, but I am saying that they knew it was there, and the delta between what the security guard conveyed and what they knew when they were investigating the case is de minimis or nothing, because all it tells you is that there's a video camera there. There were 3 sets of video cameras that probably captured this incident. None of it was presented at trial.
Mr. Sable, could you help clear up my confusion about, and I think I'm going to ask you to speculate in part, but what do you think the security guard looked at? Did she look at the wrong portion of the surveillance video? Or did she maybe look at the right portion and the follow-up where the victim is going into the neighboring building to seek video, and just fail to describe the earlier portion of the video that she actually watched?
Well, two judges looked at this and made findings that were not clearly erroneous. You know what they are. Judge Curie said it was speculative. Judge Oken said it was inconsequential, and he didn't know what she was looking at or what angle. And there were no, if we'd had the security guard to talk about, oh, well, the video shows this particular part of the street, that would have been helpful. Or if she had been able to say, yeah, we have like a 5-minute drift on these things or 15-minute drift, and so you got to go back. Any kind of information like that would have been helpful. And Judge Oken basically said, we just don't know. If you're asking
Did Judge
me,
Curie view the video? I forget.
no, Judge Curie did not. But if you're asking me, I think logically, she's clearly looking probably at the crime scene. So yes, it's helpful, but she's looking at it afterwards because she sees the victim go around the back of her car into the building across the street. The victim,
So we know the camera was focused on the right place because the security guards saw the victim, what, Miss Davis, and her car.
that seems to be the right inference. I mean, if we're finding facts at this level, but yes.
But we're not, she doesn't really say anything about the interaction between Davis and Hawkins.
Exactly. That's why it's speculative to think that anything on this video was really helpful or not helpful, although I'm not going to quibble for a moment that this is something that we should have been turning over earlier. But it's just, you can't find suppression here. And then I would just lastly say, since I haven't said this yet, it's certainly not material. This case was a credibility contest, and Judge Oken listened to both witnesses. They both testified. He watched the body-worn camera of Miss Davis on the scene telling Officer Ack what happened, and he watched the body-worn of the defendant telling the police when he was arrested what happened. And he also used his common sense where, you know, we have an allegation that somebody threatened somebody with a gun. You know, he drives off and she stays behind, waits for the police, calls 911 and starts walking around looking for security video. And he said, I credit you. I don't credit you.
But as with all Brady, the Brady might change the whole trial. And Kyle's talks about, you know, looking at the, you know, the best use a competent lawyer would make of the Brady.
Absolutely, Your Honor. And so I'm asking you, how will we get to materiality without rank speculation? What do we have that's more than speculation about what that video would have shown?
I guess I just wonder if there's so many cases where I agree with you, rank speculation. There are like a lot of cases where a defendant is saying the government should have handed over this videotape or that videotape, or surely some videotape caught it. And, you know, we have no idea whether that videotape was even pointed in the right direction. But this is an interesting case because we actually have some evidence. You know, I understand you don't think it's good evidence, but of what the video contained.
I agree. And so the court is sort of put in a little bit of a weird situation in these. I wish we'd had this earlier because then we would have gotten X evidence. And then what is X evidence when you don't have it? But what we know is at this posture, if you choose to bring the Brady claim in this posture, you're asking the Court of Appeals to look at the box that was down below, and you've got to show suppression and materiality. And if you can't show it, we win. And if that seems unfair to you, one option, Your Honor, and I would just say one option would be you bring this in the 23-110, you still go get the security guard, you get some information about what that video shows. Okay, the video is not there anymore, but a lot of your questions that you're asking me could have been answered in an evidentiary hearing. It's just not fair to come to the Court of Appeals and say, oh, there's this black box. We think maybe we want you to speculate that it was exculpatory, suppressed, and material, and the government loses because we don't know what's in the box.
Well, it's not just that, though. It is, why don't we know when this was requested? The government had it in its possession. The government knew it was exculpatory. The government knew that videos go away, and it didn't turn it over in time.
We all know videos go away, everybody. And in every case that happens in DC, I mean, we're not London yet, right? I mean, what do defense lawyers do with videos right now? I mean, they go out and they look for them. We all go out and we look for them. Although I do think, Your Honor, I think as a practical matter, let's be aware, that are they being subpoenaed, or are you going out and looking over the security guard's shoulder to try to see if it's good for you or not? Because you don't want to preserve evidence for the government if it shows that your guy's doing something you shouldn't be doing. But as a practical matter, they didn't get this video. They could have gotten the video. They made a decision not to get the video. Maybe you won't blame them for it, but you have to admit, they chose not to get the guard. They chose not to get the video. We should have turned it over earlier, but that's only
I
one
don't
of
know
three
if
steps.
that, I'm not sure that that's what the record says. The proffers at the hearing before Judge Curie seems to be saying, we went there and we took no for an answer because we didn't, you wouldn't take no for an answer if you had the body worn camera because you would know there was something there. So, he said, we took no for an answer. We did our due diligence. We tried, but they said, no, we don't have it or something wrong with that. So I'm not sure they made a choice. At least I don't think that's in the record. I think the opposite is in the record, that they tried, and the defense lawyer proffered that had he known that it was, there was that video as described by the security guard, he wouldn't have taken no for an answer. He would have sought the government's assistance,
I think he said, I think the proffer was a little more cagey than that. It was something about, we don't have anything important or we don't have anything relevant. They didn't say we didn't have the video. I mean, I don't know. All we know is what he told Judge Curie. And I guess you could look at that and draw your own conclusions. I think if I'm the government and I'm doing that, I'm sending a subpoena over there. I'm getting the guard's name. I'm getting the video. I'm doing that. And I can't imagine why they didn't do it. They could have done it if you're the defense lawyer as well. And so that's why I just think, yes, we try to turn this stuff over, Your Honor, but I don't think you have suppression. You don't have materiality. And 2 trial courts looked at this and they made factual findings about the information.
except Judge Curie didn't even look at it.
Well, she went on the defense lawyer's proffer, which is he could have shown it to her supposedly if he thought it made a difference. And what she said, bear in mind what she said was, she didn't say there's no crime here. She said, I didn't see anybody get out of or get into a car other than, as you said, Miss Davis going around the back of the car.
Judge Curie heard the motion, I think, on the same day the case was certified to Judge
Yes.
Oken for trial.
Yes.
And by that time, defense counsel had the body worn camera footage.
2
Did he
months.
make any effort to show it to her, or did she decline the opportunity?
Neither, as I recall, Your Honor. He just said, this is what the body worn shows, and this is what the security guard said. And she said, that's speculative. I'm going to deny your Brady motion. I'm going to deny your Rule 16 motion. And then it comes up again at trial. And at first, Judge Oken says, well, I'm not going to revisit Judge Curie's motion, but then he uses it for impeachment, and it's a motions hearing combined with the trial hearing, and it starts coming in for the motions hearing, and then eventually Judge Oken says, okay, it's all coming in for evidence at the trial as well.
I'm struggling for a legal rule that captures this bizarre situation. Let's assume we have surveillance cameras mounted on buildings, but the owners of the buildings are cheap. They re-record every 5 days. And so there's no practical way to get the body worn camera disclosed to the defense before the video is erased. Is that a Brady violation?
The standard that this court has set out, other than exculpatory and materiality, is suppression. Did the defense receive it in time to make effective use of it? That's a fact-specific inquiry.
But
And I don't know of any
that's
rules.
a nub here. Ms. Resnikoff insists that the surveillance video is exculpatory. And her client never had an opportunity to make use of that. Why? Because the government waited 60 days or so to turn over the body worn camera. So there's a cause and effect here where she thinks she never got the opportunity to make the use of the evidence in the video camera.
She did not perhaps get the opportunity that she wanted, which is what Judge Beckwith is, I think, asking me. But that she had the opportunity. There's always evidence in private hands, and everybody should be going out there and getting it as soon as possible. We all know that, but there are constraints of resources. And with the security video, 30 days is pretty common, and I would think everybody's on notice of that. The government tries to turn over the body worn within that 30-day frame, but we didn't in this case. And but the court hasn't set a rule, nor do I think it should, because the standard is the due process standard of making effective use. That might be a Rule 16 issue potentially, but we're talking about Brady here, which is due process. And again, Your Honor, there's the Terry case and there's the Maccabee case. And again, those were cases where there were mis-IDs that were late disclosed. And again, the arguments were, among other things, hey, if you turned over this information about the mis-ID earlier, because we're talking about homicide or AWICS, we're talking about years now. We could have investigated this. We could have done X, Y, and Z, but the court said, you still need to do more. You need to bring more to me. You can't just ask me to speculate about what you would have found if you had received it earlier. And here, Mr. Hawkins is in the same boat, except really with less to stand on. He's asking you to speculate about what's in that black box of the security video. And unless you can say, well, at most, I would say with Judge Fisher, it seems to capture the scene. That's all you can really say. And then you do have what the security guard said about the time, but it doesn't seem like she could possibly be right. But at least we could be curious about it. But I don't know how you get to materiality or suppression. The court has nothing further. I'd ask the court affirm. Thank you.
Thank you very much. Ms. Resnikoff will give you 3 minutes for rebuttal.
Thank you, Your Honor. I have a few things I'd like to talk about, which is, first of all, the defense attorney at the hearing level did ask if Judge Curie wanted to see the video, and she said no. She said, I'll just listen to what you have to say about it. So he did offer that. I think something that's important to highlight here as well is that this video was from a police officer who was standing there hearing this eyewitness say, I looked at this video, I didn't see anyone get out of the car, directly contradicting what the complainant had been saying. And so that's the government. The police officer is an arm of the prosecution. They have this exculpatory information. Even if the police officer should have done something about this, they know, but we don't have any, did he take a note on her name? What if he had taken notes on this person's name? Then we could have gotten the security guard, because we still don't have her name. And I think the whole point of Brady is just to prevent these sorts of things from happening. The government has knowledge of this information and hid it.
I think you're mixing up two things, and I'd like to separate them in a way that might be helpful. If the officer knew what you just said, maybe the option would have been for him to tell the prosecutor and the prosecutor to tell defense attorney, and then the defense attorney to go find this evidence. But at times you seem to be saying it was the government's obligation to conduct an investigation to gather evidence for the defense.
No, Your Honor, I'm saying that when they have information that is material and exculpatory to the defense, they need to disclose it in time for the defense to use it.
But you talked about failure to get the guard's name.
Well, we don't, as far as I can tell, we don't have that, but
Apparently not, but is it a Brady violation that the officer did not learn the guard's name?
no, but I would highlight that the officer is seeing something and hearing a person say something that completely contradicts the complainant. And the defendant has always said there was no crime here. We had a minor dispute. It was over, never got out of the car. So when the police officers are still investigating, there's still he's not guilty yet. You know, they could have looked into it. They didn't, but the defense doesn't even know that they need to look into it until they get the body worn camera. And I think, Your Honor, when you're trying to craft this rule that would be helpful, the rule is Brady. Because this is, you know, helpful information for the defense and.
You haven't come up with any Brady cases that are even remotely close to this factually. So if you could come up
Well-
with a better content for Brady, I'm happy to listen.
I will take another look at the case law and see if I can find something even better. I think the government talked a lot about speculation about what would be on the video, but again, I think because of what is on the video, it's not really speculation that it captured the scene and would have captured my client say, you know, nothing happened and just supported his posture on this.
What's the, how much does it matter that there are all these comments about the government doesn't have a duty to investigate or to find and uncover Brady, but there's like in Vaughn, there's a line that says Brady does not tolerate the government's failure to turn over an easily turned rock. But, so there must be some things that the government is onto and doesn't have to actually do a separate investigation to be able to know. Is that your understanding of the law, and where is that line?
So I don't even think we need to get to the uncovered rock, because the police officer, again, the government had this information about this evidence, but by the time the defense gets it, it can't be found and used. So that's the government's burden. If they had never gone back and interviewed this witness, we don't have this BWC saying, oh, there's a video. Oh, I didn't see anyone get out of the car, but they did. This is part of something. Once they have it, they have to turn it over, and they have to do it in a timely way that the defense can use it. And that just wasn't done here.
And does the timeliness depend on what the common practice is among private companies? What their practice is about how quickly they erase the video? That is it a moving target? If they shrink it to 20 days, then that's the timeliness mark for the government?
I think here they were too late. I don't know that there's a specific mark out there. I know that in the government's initial discovery packet, they talked about, we try to get these videos out before your first arraignment, which they didn't do, or your first hearing, which they didn't do. So I don't know if they have a policy, but the police officer was there and they knew that someone had said something, indicating that there was no crime. So they were firmly knew about it.
So is that, it is a concern, as Judge Fisher says, if you got relief in this case, would we be going to a place where the government is on the hook for every video that, doesn't get turned over, that might be destroyed in 10 days or 5 days? Why isn't your case going to lead to something like that? If we say you get the Brady 2 months before trial, and that's not good enough.
I think that in this case, it wasn't good enough. And I would imagine in others, it's also not good enough. And that because of the way this system is set up with the protective order and the body worn camera, and, the defense attorneys are on this, we consent to the protective order. There's really nothing stopping them from doing it that same day. They can send in an email or put it online. So there's really nothing holding them back. And then again, if there's anything in there that shouldn't have been disclosed, they're covered by this disclosure that the defense agrees to. So there's no like extra harm to the government from just simply, sending it over immediately. And I thank the court and to please reverse and dismiss this information against the client. Thank you.
Thank you, Ms. Resnikoff and Mr. Sabo, for your arguments today. The case will be submitted and we're adjourned.
All right. This court is now adjourned.